Right now, as I explained earlier, I can't grant you community control in count 7. So there will be a prison term. You understand that?
Yes, sir.
All right. Now, the charge in count 1 alleges that on or about April 21, 2023 in this county, you did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance, an amount equal to or exceeding bulk amount but less than 5 times bulk amount, and you had previously been convicted of 2 felony drug offenses, to wit, illegal assembly or possession of chemicals or manufacture of drugs in violation of 2925.041A in Highland County Common Pleas Court, case number 17 CR 98, on April 26, 2017, and aggravated possession of methamphetamine in violation of section 2925.11 in Highland County Common Pleas Court, case number 09 CR 0055 on December 8, 2009. In violation of section 2925.03A1. So that's the charge in count 1. Count 5 alleges the same language, except that it says that you committed the offense on or about April 25, 2023. Then count 7 alleges that on or about June 16, 2023 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule 2 controlled substance, an amount equal to or exceeding bulk amount but less than 5 times bulk amount in the city of the school zone, and that you've had the 2 previous convictions that are alleged in counts 1 and 5, and that this offense oh, okay, I overlooked it. I was looking, usually the allegation of the vicinity of school zones at the end of the indictment, but it was actually in the earlier part where it said it was more than bulk amount but less than 5 times bulk amount in the vicinity of the school zone. So it's the same as the other 2 charges, except it's alleged it was in the vicinity of the school zone. And that's the second degree felony we talked about. Now, Mr. Yost, do you understand each of those 3 charges, what the state alleged you did, and when, where, and how they alleged you did? And you understand the possible penalties and the required mandatory penalty for count 7?
Yes.
And you understand the penalties for the other 2 charges as well?
Yes, sir.
Now, have you discussed the nature of the charges, the evidence in the case, the possible legal issues in the case, possible defenses you could try to raise in a trial, and the possible outcomes of a trial with your attorney?
Yeah.
Are you satisfied with his advice and confidence in this matter? Are you under the influence of any types of drugs or alcohol at this time?
No.
Has anyone threatened you to make you plead guilty here today?
No.
Now, on page 2 of the agreement, there are 3 lines that are printed in bold and underlined, and those read as follows. Defendant shall enter a plea of guilty to counts 1, 5, and 7. State will dismiss remaining counts. State defense jointly recommend 12 months on counts 1 and 5, consecutive to 3 years on count 7 for a total of 5 years. And defendant shall repay bond money of $550. Is that your understanding of the agreement?
Yes.
Okay. And in terms of that agreement, so you understand that 3 years on count 7 would be mandatory. The other 2 are not, which means you could be eligible to apply for judicial release after you serve that required time. You understand that?
Yes.
All right. Now, under the law of Mr. Yost, the recommendation on sentencing is not binding on the judge. And so if you plead guilty, I'm not required to follow that sentencing recommendation. I could impose the 3 years maximum on each of the first 2, the counts 1 and 5, and the 8 years mandatory on count 7, which would be potential 12 years if the DRC extended your sentence. And those could be all served consecutively. So as I indicated earlier, it could be a sentence of 14 to 18 years. You understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation in the state of Ohio?
No.
Do you have certain constitutional rights, which understand, before I can accept this plea, you have a right to counsel. Mr. Blosser was appointed to represent you. Now, his appointment isn't simply to try to see what kind of deal can be reached, but to represent you and defend you in any way that's permissible under the law, if you would like him to do that. So you understand that if you didn't want to take this offer, he would continue to represent you and defend you, including a trial, if that's what you want.
Yes, sir.
Now, under the Constitution, in this case, and on these charges, Mr. Yost, you have a right to have a jury trial of 12 people who would be selected from a group of citizens who live in Highland County that are summoned for jury duty on your trial day. After they are selected, the evidence will be presented. They would then be instructed on the law by the judge, and that jury of 12 would decide by unanimous verdict, meaning they would all have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up the right to have a jury trial. And in that case, you would have what's called a court or bench trial, meaning that instead of a jury, it would be a judge who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, Mr. Yost, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that would help your side of the case. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're uncertain are going to come in voluntarily, at your request, the court issues a court order called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes.
Now, under the Constitution, Mr. Yost, you have a privilege against self-incrimination, which means you cannot be forced to give evidence or to testify in this case at any time, including trial. No one can make you testify. The prosecutor can't, the judge can't. It's your decision. If your decision is not to testify at trial, that fact cannot be used against you in any way by any person, and no one's even allowed to comment about it, except in one situation. Should there be a jury trial, then the judge, and you don't testify, then the judge does instruct the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Now, under the Constitution, Mr. Yost, you're presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of each offense by proof beyond a reasonable doubt. What that means is the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused of these crimes. In fact, under the law, you don't have to present any evidence at all at trial in your own defense. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on each of the 3 counts by proof beyond a reasonable doubt on every essential element of each offense, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Now, Mr. Yost, originally you entered a plea of not guilty, which denied the allegations in the indictment, denied you committed any crime, and exercised or invoked all your rights that I just described. If you change your plea from not guilty to guilty on these 3 counts, that's the complete opposite of the guilty plea. A not guilty plea denies the allegations in the indictment, denies you've committed a crime, and it exercises or invokes, waives or gives up all the rights that I've just described. So a plea of guilty says, I did it. What it says in there in those 3 counts is true, and then I'm guilty. And that plea waives or gives up the rights that I've described for you today, except one, your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty waives or gives up your right to a jury or court trial, waives or gives up your right to confront the witnesses against you in open court and to cross-examine them through your attorney. Waives or gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. Waives or gives up your privilege against self-incrimination because you're saying you're guilty and that's what's used to find you guilty. It waives or gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal for any alleged violations of your rights you feel you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence or under other limited circumstances there could be an appeal, that would have to be filed within 30 days of the entry sentencing you is filed. Do you understand all of that?
Yes.
And are you a U.S. citizen, Mr. Yost?
No.
Are you a U.S. citizen?
Yes.
Okay.
Your Honor, I'm sorry to interrupt, but I just caught something as you were going through this. So, counts 1 and 5, as they're currently charged, because it contains the language of the prior convictions, carry mandatory time. The state unintentionally omitted from that plea form, we would strike the language regarding the prior convictions as the counts 1 and 5 to make that time non-mandatory. That was omitted from the plea form. That was a mistake on our part.
All right, and Mr. Blosser, I'm sure you have no objection to me adding that? Okay. All right, so I'm going to add here, allegation of prior convictions in counts 5, or 1 and 5 are deleted. Okay, Mr. Yost, just explain that to you, and I'm glad Mr. King caught it because that's in your favor, because under the law, if I had sentenced you according to this, if you plead guilty, the DRC has people up there that review the entries to see if the judge made a mistake, which in this case it would have been my mistake. I have to take responsibility, but it would have been Mr. King's fault. But in any event, they would have called back or sent me a letter that says these are mandatory sentences, so your sentence isn't correct. Do you want to change it? Do you want to change it? Then I would have had to say, yeah, I've got to bring you back. So by doing that, that makes this plea agreement comply with the law. So just so you understand that. You have any questions?
No.
Okay. All right. Now, you understand the charges against you as amended in count 1 and 5 and count 7?
Yes.
And you understand the possible penalties for those?
Yes.
And do you have any questions about the plea agreement?
No.
You understand?
Yes.
Any questions about your constitutional rights? You understand those? Do you have any questions about the plea of guilty, what it means, or what will happen if you enter that plea here to these 3 charges today?
No, sir.
You understand?
Yes.
Is there anything you need to speak with Mr. Blosser about before we go any further?
No.
Do you have any questions at all about anything that I've explained today or anything that's taken place?
No.
You understand?
Yes, sir.
Then it's your decision, Mr. Yost, to go forward and plead guilty to counts 1 and 5 as amended and count 7.
Yes.
All right, then, as to count 1 as amended, that reads that on or about April 21, 2023 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine and a Schedule II controlled substance, an amount equal to or exceeding bulk amount but less than 5 times bulk amount, in violation of Section 2925.03A1, third-degree felony with a non-mandatory prison term of between 9 and 36 months in increments provided by law, a possible fine of $10,000, a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead? And then count 5, which reads the same as amended, except that the date of the occurrence was April 25, 2023. Otherwise, the same allegation, the same offense, same penalty. How do you plead? Then as to count 7, which would allege that the 2 prior felony convictions remain in there, Mr. King.
Yes, Your Honor, that would not, to my understanding, that would have no effect.
Right.
Mandatory regardless.
Okay, that's what I thought, because it was already mandatory time. All right, so then it reads that on or about June 16, 2023 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, Schedule II controlled substance, amount equal to or exceeding bulk amount less than 5 times bulk amount in the city of the school zone, and that you had previously been convicted of the 2 felony drug offenses we talked about earlier, in violation of Section 2925.03A1 of the Ohio Revised Code, which is also the charge of aggravated trafficking of methamphetamine in the vicinity of the school zone, a second-degree felony carrying a mandatory prison term of 2 to 8 years set by the judge, and a maximum of up to additional one-half of that added by the DRC, a fine of $15,000, a mandatory fine of $7,500, and a possible license suspension of 6 months to 5 years. How do you plead? All right, the court finds that on this day in open court, defendant was advised of all of his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal Rule 11. The plea is accepted and ordered filed. Defendant is found guilty of counts 1 and 5 as amended, and count 7. The remaining counts of the indictment are dismissed. All right, since there is a mandatory prison term on count 7, and there's an agreed recommended sentence, the court's not going to order a pre-sentencing report, so I'll go ahead and proceed the sentencing forthwith. Mr. King, on behalf of the state, anything you would like to say?
State would just ask that the court follow the joint recommendation and order restitution as outlined in the plea agreement. That's all, Your Honor. Thank you.
You have jail time. Mr. Blosser?
Your Honor, thank you. We would ask the court to follow the joint recommendation in this matter. I would also note that I believe he has previously filled out an affidavit of indigency, an action for finding of indigency with regard to mandatory fines and the charges, not necessarily the fine money, which is part of the plea agreement. So it's significantly less anyway, but I would ask the court to consider that as well, please.
All right, I will. All right, Mr. Yost, anything you would like to say? All right. And you agree with your attorney there's been no change in your financial circumstances since I appointed him to represent you?
Yes, sir.
Okay. All right, then it is a judgment order of the court that the defendant be and is hereby sentenced on count 1 and 5 to a term of 12 months on each count, and on count 7 to a mandatory term of 3 years. And that would be a total then of 5 years. Those sentences are, because those sentences are ordered to be served consecutively for the reason that the parties have recommended a consecutive sentence. The offenses were committed as part of a series of conduct that would, in one single sentence, would not adequately reflect the seriousness of the offense. And given the defendant's previous criminal history as detailed in the original allegations in count 1 and 5, although dismissed, they are also reflected in the file. The court finds that the history of criminal conduct is necessary to protect the public. The court will also find that the sentences are not disproportionate to the harm caused and are almost the minimum in counts 1 and 5 and almost the minimum count 7. So those are minimal sentences on the possible maximum ranges. Now, upon completion of the sentence, Mr. Yost, it is mandatory that you be under post-release control supervision for a period of at least 18 months under up to 3 years as determined by the adult parole authority. And that means you'll be supervised under the terms they set. And if you violate those conditions, then they would have the right, even though you've served the entire term set by the court and possibly extended by DRC, for a period of up to 9 months for a single violation, although the maximum or cap is half of the prison term for all violations. But if you commit a new felony, then in addition to whatever sentence a judge in the new case can impose upon you, that judge could also sentence you in that case for committing it while under post-release control, in this case, to an additional period of a year, or whatever time is left on the post-release control period, whichever is greater, that would have to be served consecutively to the sentence in the new case by law. It's also ordered you, as far as jail time credits, you were arrested on March the 1st, is that correct? All right, so that totals 56 days of jail time credit. It's also ordered that you pay $550 restitution to the Heightens County Task Force through the victim witness restitution escrow account and pay any certain fees connected to that. And that is a substantive sentence that will remain even after you serve your entire prison term. It could be enforced by the court in future action. Court will waive the mandatory fine in each count, finding that the defendant is not presently capable and will not likely be capable in the near future to pay those fines. You all are also ordered to pay the court costs, which judge will grant execution order. If you do not do that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out, the court could permit you to do community control or community service in this county and be given credit for each hour you worked and an hourly rate set by the court. Each hour you worked will reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
No, Your Honor.
All right.
No, Your Honor.
All right. You'll be remanded back to custody and be transported, Mr. Yes, thank you.